Good morning, everyone. It is bang on 10 o'clock, so I'm going to hit the ground running with this one, bright on a Monday morning, because we've got quite a bit of content to go through. For those of you who don't know me, good morning. I'm Meg Martin. I'm the Human Rights Lead here at QCOS, and I would like to start by acknowledging the traditional owners of the land on which we're meeting today. I'm based in West End in Brisbane, so it's the Turrbal and the Yuggera people, and pay my respects to the elders past and present. QCOS thanks the First Nations people for the gift of the Uluru Statement of the Heart. We look forward to supporting work leading to a successful referendum and to enshrine a First Nations voice to Parliament in the Australian Constitution, followed by Makarrata and treaty. QCOS welcomes the invitation to walk with First Nations people in a movement of the Australian people for a better future. QCOS is, for those who aren't aware, the peak body for the community service sector in Queensland. Our vision is to achieve equality, opportunity, and well-being for every person in every community. Our values include respect, optimism, and strength, and we advocate for a strong social service safety net delivered through our community service sector and social policies that improve outcomes for all Queenslanders. So our presentation today is by the Human Rights Commission, and I'm very grateful to have Heather Corkhill with us today, who is going to present the Building Belonging report, which is a review by the Human Rights Commission into the Anti-Discrimination Act. So I'm going to introduce our speaker, Heather. Heather is a Senior Policy Officer at the Queensland Human Rights Commission. Heather has a background in law and creative arts, and Heather has a decade of experience working in alternative dispute resolution, specialising in discrimination, sexual harassment, and human rights. Heather's policy work is focused on developing systematic responses to discrimination and human rights issues in Queensland, evaluating and reporting on the progress of the Human Rights Act, and most recently, reviewing the state's discrimination laws. Just a tiny bit of housekeeping before I hand over to Heather as well. For those of you who are with us, we do have a chat function at the bottom of the screen. We will be providing copies of the slides in a post-event email as well as a copy of the presentation. So if we have time at the end of the presentation, we will take some Q&A. You can unmute yourself at that time to ask questions or put that in the chat. So if you've got questions that pop up during it, please feel free to put that in the chat function at the bottom and we'll take note of that. And if we don't have time, Heather's very happy to take those on notice and respond to those as well. So I am going to pass over to Heather, who is going to talk to us about the Building Belonging report that's been done by the Human Rights Commission. Thank you, Heather.
Hello, everyone. Thanks for that warm welcome, Meg. So I just wanted to add to Meg's acknowledgement of country that I also would like to pay my respects to the traditional custodians of the land on which we're gathering today. In my case, it's the Yuggera and Turrbal people as well. I'm sitting here in Meanjin and not too far from the bend in the river Toogoolawah. So today we'll be talking about the Building Belonging report. So last year, the Queensland Attorney General asked the Commission to conduct a review of the Anti-Discrimination Act. We were asked to consider whether there's a need for any reform to enhance and update the Act, taking into account Australian and international best practices, to best protect and promote equality, non-discrimination, and the realisation of human rights. So the report Building Belonging, it's probably a bit blurry here. This is a 400-page report, so clearly we won't be able to go through the whole thing today. But what I've included in this presentation is hopefully the aspects that are most relevant for those working in the social services sector, both from the perspective of supporting your clients, as well as being duty holders under the Act as well. So as you'll see, there's an overview of what we'll cover on the slide. So our approach to the review, some of the key reforms, key concepts, so that's like about meaning of discrimination and other concepts in the Act that are most important, updates to the process for making complaints, the eliminating discrimination, which is about a positive duty to prevent discrimination, and then some information about attributes and exceptions as well. Okay, so in terms of our approach to the task, we had 14 months to conduct the review. And because there had never been another review of this scale ever for this Anti-Discrimination Act, and it really hadn't been looked at closely in 30 years, we knew that consultation was absolutely key to our process. So the review had a reference group, which was made up of peak bodies, including QCOS, and there's representatives of various sectors, including religious bodies, commerce and industry. And we sought feedback from those stakeholders, and also use that reference group to reach stakeholders as well through the process. We had more than 120 stakeholder consultations over the course of the review. One of these was a workshop co-facilitated with QCOS, where we sought the views of the sector through an interactive forum. I think around 300 people came along to that. So that just shows the interest that there was in the social services sector. We received around 130 submissions to our discussion paper and around 30 other submissions. We held 4 public consultations in regional Queensland, and we held 6 specialist roundtables, including with children and young people, and also with people with disability. We also conducted an online survey to make sure that the process was accessible as possible. It didn't require any prior knowledge of what's in the law, but asked questions like around what experience people had of discrimination, and what impact there'd been of those experiences, and what they'd like to see change. We had around 1,200 responses to that survey. So an incredible amount of engagement, and I'm really grateful for people who were so generous in sharing their experiences with us, and in the hope of making the system stronger for the future. So what does the Anti-Discrimination Act cover now? So this is for only, many will probably be quite familiar with this, but in terms of what the Act is about, it's about protecting people against unlawful discrimination, sexual harassment, vilification, and other kinds of unfair treatment. Vilification was not part of our review, so it had been carved off and had been dealt with as a separate review by a parliamentary inquiry process, which has already reported its findings, and I understand that that has already progressing as we speak. And we're hoping that the vilification reforms will sort of join up with the Anti-Discrimination Act reforms that we've looked at to hopefully create one bill to make these changes. So discrimination at the moment is only unlawful if it occurs on the basis of a protected attribute, and it's got to be in an area of public life. So that might include education, work, or receiving goods and services. So I guess why address discrimination and sexual harassment? So what we know from research is that discrimination has multiple layers of harm that it causes. So there's, of course, harm to society in terms of the impacts on social cohesion, and also what came through very much from when we asked people about their experiences of discrimination and the impact in that survey, that it certainly has harmful impacts on people's psychological well-being as well. And the sort of things people were reporting to us were lower self-esteem and self-worth, anxiety and panic attacks, PTSD, suicidal ideation, helplessness, and a loss of confidence. So quite significant impacts that people were telling us about, and that really correlates with what the research has been saying for a long time as well. And then I guess what perhaps isn't often thought about as much is the potential financial or productivity costs that there are from failing to address discrimination. So during the Respect at Work inquiry, Deloitte was engaged to estimate the economic costs of sexual harassment in the workplace, and have found that just in the course of 1 year, workplace sexual harassment costs $2.6 billion in lost productivity and $0.9 billion in other financial costs. And in terms of who bore those costs, that was 70% on employers, 23% on government, and about 7% on individuals. So while there's been no similar study done on the costs of discrimination that I'm aware of, we would expect it would exceed those estimates by a fairly large amount. So in terms of our early consultations, and then what we heard in submissions as well, there were 3 key aspects in terms of the limitations with the current legislative framework that we identified. So certainly acknowledging that the Anti-Discrimination Act has played a central role in protecting and promoting equality. But as I said, it hadn't had a thorough review in 30 years, and society had shifted in many ways. So Homosexuality was only decriminalised in 1991, which was the same year that the Act came in, and the Mabo decision just came a year later. So that gives you a bit of an idea of the flavour of what was happening at the time. Breastfeeding discrimination was on the radar at the moment as a new thing that people were talking about. So that's sort of where we were in 1991. But since then, Queensland's undergone so many societal and attitudinal changes. So we're now more diverse in our race and religion. Terminology has changed and shifted so much, and our family structures and relationships look different. And so it's important that our discrimination laws keep pace with community attitudes and expectations. And there was an opportunity here to really make sure that that happens. And so the issues we identified early on is that the system is very reactive. So while it's valuable to individuals to resolve single instances of discrimination, the Act seemed to be having a limited role in addressing more complex and systemic forms of discrimination. We also heard that the law had evolved in a way that isn't responding effectively to the issues that need to be addressed. So, for example, it's too complex, hard to understand. There's also inconsistencies between, say, federal and state laws that cover the same subject matter, which made it difficult for duty holders to actually know how to comply. And then finally, we heard that there are gaps in protection. That's either created by the attributes not being recognised, or sometimes the definitions of the attributes were so narrow that they didn't include all parts of the community that were experiencing the unfair treatment, or there were exceptions that didn't seem to achieve the right balance in providing protection from discrimination while allowing for some differential treatment where there's a genuine important reason for that to happen. So to address that, we suggested these key reforms. So the first is shifting the focus to prevention. And that's to deal with the reactive system that currently exists. So the idea is that you look at, try to prevent discrimination and sexual harassment before it happens, instead of solely relying on people subjected to it making complaints. The second was extending protections, so to make sure that everyone who needs protection of the Act is actually protected. And thirdly, trying to simplify and improve the system overall. And that includes the language and definitions, and then also the complaints process to make it flexible, efficient, and tailored to the needs of the people who are using it. And so in terms of the key concepts under the Act, so I'm talking about things like what is discrimination, and what's the meaning of direct and indirect discrimination. So I won't get too legalistic on this. We do have a CLCQ webinar happening on the 15th of November, which will probably go into a lot more technical detail. But just based on the case law that we read and in submissions to the review, we determined that the key definitions, so direct and indirect discrimination, had become quite bogged down in technical problems and were diluting the effectiveness of the law. So there was widespread support for simplifying these legal tests as to whether or not something is discrimination. And the review considered various options. So we looked not only in Australia, we also looked overseas. We determined the best option was to move to the approach of ACT and Victoria, because the feedback we were hearing was that the system is working fairly effectively in their newer definitions of discrimination, which are simplified. We also looked at the best way to recognise discrimination that happens because of combined grounds. So we heard a strong theme in our initial consultations about intersectional discrimination, and to address this, we recommend an approach based on the discrimination law from Canada. So that means that you could make a complaint on the basis of your race and age, if that is the reason for your treatment, as opposed to it is just because of my age or it is just because of my race, because that often doesn't cover all types of unfair treatment that is actually happening. Reasonable adjustments or reasonable accommodations is something that's probably quite well known to many of you, and it's a core concept of discrimination law. We heard from people with disability in particular that duty holders didn't really understand their obligations to make reasonable adjustments to meet their needs. And this is partly because of the way it's framed under the law at the moment. So we recommended following the approach of other jurisdictions, including Victoria, to have an express positive obligation to provide reasonable accommodations with a list of really clear criteria to assess as to whether something is reasonable adjustment in a fair and balanced way. The complaint system one of the key problems is that it's quite prescriptive and quite bogged down by rigid procedural requirements that require all matters to really be dealt with in exactly the same way. And we recommend reshaping the process to make it more flexible, responsive and tailored to the needs of the complainants and respondents who use the dispute resolution service. Other improvements to access to justice and the accessibility of the process include making it a longer time limit to bring a complaint. Currently, it's 1 year, and we recommend changing that to 2 years, allowing for verbal rather than only written complaints to be made, and also for the Commission to provide reasonable help to assist people in exceptional circumstances to put their complaint in writing. Another really key development would be to allow relevant entities to bring a complaint on behalf of an affected community, which we call in the report an organisational complaint. So that would reduce the burden on individuals who've experienced discrimination and boost the capacity to address systemic issues and issues that are also in the public interest. So it's often that a whole community, let's just say the people of Sikh faith, are all impacted by the same discriminatory policy. But at the moment, it requires one person of Sikh faith to actually put themselves forward as the complainant in order to address that. So we're saying that perhaps an organisation that represents people of Sikh faith could make a complaint on behalf of the whole community, and that would just reduce the burden of individuals making the complaint, and would be very much more focused on, rather than individual instances of discrimination, but improvements to, say, public policy. Okay, so a key reform that we recommend in the Act, in the report, is to for a positive duty to be introduced, to take reasonable and proportionate measures to eliminate discrimination and sexual harassment as far as possible. Now, this was actually part of our terms of reference to consider this, and it has been, it's a sort of a new feature of discrimination laws. So we've seen it recommended in the Respect at Work report, for example, and there is a positive duty in Victoria, in the Equality Act in the UK and other places as well. So the idea is that, because, as I said before, enforcement of the Act is currently relying on resolving complaints. So it's often about conduct that's already happened. And so that places the burden on people who've experienced discrimination and sexual harassment to bring complaints in order to prevent future behaviour. So it means that organisations aren't really required to do anything unless someone brings a complaint and can prove that they haven't discriminated. So that's not only unfair, but it's fairly ineffective. So even if people do lodge complaints, the capacity of that process to address broader systemic issues beyond that one individual instance of discrimination is quite limited. So this means the Act may not be having a real impact on the daily lives of people the legislation aims to protect. So what is a positive duty? So positive duty is an obligation on a person or organisation to take proactive steps to prevent discrimination and sexual harassment before it occurs. So that focus becomes on prevention. And so it would apply to any entity operating in an area covered by the Act. So that would include employers, schools, education providers, businesses or organisations such as non-profit organisations and so on. And so what could an organisation do to discharge their positive duty? So they could do things like familiarising themselves with the Anti-Discrimination Act, ensuring leaders and managers are aware of their obligations through formal and informal education and training, developing a prevention plan based on guidance material and implementing policies and procedures with a more preventative focus, considering the extent to which organisational culture models respectful behaviour, and monitoring and evaluating any systemic issues. So what we have recommended is actually the same as what's in Victoria, in terms of it needs to be scaled depending on the size and capacity of that business or operation. So that will include considering the resources available, operational priorities, the practicality and the cost of the measures, and any other relevant factors. So we don't expect that necessarily a large organisation can do the same as a small business which hires one person. So that's just logical, of course. And in terms of the positive duty, we got a lot of submissions on this topic through the review, and about 3/4 were actually in support. One of those was QCOS. And the consistent theme was about the preventative focus being a priority for stakeholders. And so while the Anti-Discrimination Act currently requires steps to be taken to prevent discrimination and harassment from occurring, that's actually only as a defence, which is raised in response to a complaint. So that doesn't actually require anything to be done unless a complaint's being made. So that would be the sort of key difference. What we actually heard from Victoria was that enforcement powers for a commission were necessary to accompany the positive duty. So while Victoria has a positive duty, it hasn't been as effective as it could be because there is no sort of there's no powers for the commission to intervene in any sort of meaningful way. If there is an organisation or sector that is not meeting that positive duty. And so we recommend that the Commission, so the Queensland Human Rights Commission, does have those powers, but we also recommend that they're very much dependent on the resources of the Commission, but also on priorities as well. And, you know, as an organisation which is currently about 45 people, we certainly can't be everywhere and doing everything. So we would absolutely be looking at strategic priorities in terms of how we would enforce positive duty. And if you imagine a triangle, then, you know, certainly the bottom part, or a pyramid, sorry, the bottom part of the pyramid would be where we would actually focus almost all of our attention. So that would be in developing education and awareness materials. The second sort of part of that pyramid, the higher part, would be cooperating to address systemic issues. So working with business and industry to perhaps create guidelines and things like that to work together to address issues. And then really it would be only the pointy end of that pyramid, which would be addressing non-compliance. So we wouldn't be looking at that except in the most exceptional circumstances. And also to ensure that there is time for organisations to actually put measures in place, we recommend that those at the pointy end of the pyramid, so those ways in which we address non-compliance would not actually kick in until 2 years after the commencement of the Act, and that's actually more time than the Human Rights Act. So that our experience was that was not long enough to get organisations, or it's not, I should say, public entities on board to do what they needed to do to prepare for the Human Rights Act. So we think realistically there needs to be a couple of years of lead-in time. And the Commission would absolutely be prioritising engaging with duty holders around that time to work together to make sure it's really clear what's required. Okay. So the next aspect I'll have a talk through is about updating attributes. So we were asked to actually look at the current attributes that were in the Act, and we identified, so there's currently 16 attributes or characteristics which the Act protects people from discrimination on the basis of. And we were looking at particularly, were they still relevant? Did the list need to be expanded? And also with the current attributes, how was the language actually up to date? Were any changes necessary? So you'll see on the slide, we've actually, I've set out what the changes we've recommended are in simple terms. So impairment becomes disability, gender identity would be a new expanded definition. Sexuality becomes sexual orientation with a new definition. Lawful sexual activity would become sex worker. Race would be clarified to include immigration or migration status, because that's not completely clear at the moment. And family responsibilities as an attribute would become family, carer or kinship responsibility, so a broader attribute. So the changes we're recommending here are really aimed at fixing a few different issues. So the way that existing attributes are defined has meant in some cases that people who should be protected are not. So for example, people are protected from discrimination on the basis of their sexuality under the current legislation, but the definition of sexuality in the Act is confined to heterosexual, homosexual or bisexual. So anyone with a different sexuality, including people who are asexual, are not protected by that. In terms of family responsibilities, we recommend that be expanded to include carers other than immediate family members, to recognise the importance for people with disability of carers. and to recognise diverse contemporary family structures and cultural responsibilities as well, in terms of kinship responsibilities. In some cases, we found with the attributes, the language that's actually used to describe an attribute or its definition has meant that people don't realise that they're protected, even if they are. So one good example of that is disability. It's currently called impairment, as I said, which just isn't usually how people refer to disability in everyday life. And there were also other gaps that we identified in the definition of disability as well, and recommend that it gets aligned closer with the Federal Disability Discrimination Act for consistency and also for better coverage as well. We also were asked in our terms of reference to consider if new attributes should be protected as well, considering that those attributes hadn't been looked at for about the last 20 years, where we had the recognition for the first time of sexuality and gender identity and family responsibilities that came in around that time. But of course, there'd been so many changes in community expectations and groups experiencing discrimination in that time. So we recommend the following additional attributes in the review. So sex characteristics, a relevant criminal record, physical features, being subject to domestic or family violence, and homelessness. And in terms of our considerations, so we wanted to make sure that in doing so, we had a very robust framework for including new attributes. We were concerned that there was a risk of diluting the effectiveness of the law if the list of attributes becomes so long that duty holders don't know how to comply with their responsibilities, which was already a bit of a concern. We also needed to make sure that the inclusion of any new attributes needed to be sort of objectively justifiable. So we actually asked ourselves 2 questions in relation to each proposed new attribute. Is there a gap in protection? So is there actually some unfair treatment that isn't already covered by an existing attribute? And also, is the proposed attribute of a comparable nature to those already covered by the Act? So attributes at the moment are things like immutable characteristics. So for example, your age or race. Sometimes they can also be groups that have experienced historical marginalisation. So those are usually the groups that are protected. So we were sort of using that framework in order to identify was there a justification for any of these new attributes. So in terms of these additional attributes, I thought those are the most relevant to the social services sector, maybe inclusion of domestic or family violence and homelessness. So I thought I'd talk through those in a little bit more detail. So people were telling us in consultations about domestic and family violence based discrimination, and they're often about workplace related issues, including not being given a promotion because of a perception that violence someone was experiencing would impede their performance. Things like she'd be better off sorting herself out before pursuing a leadership role. We also heard about examples where people's employment had been terminated because they were thought to pose a risk to health and safety because of the violence that they were experiencing, such as an abusive partner had showed up at the workplace, and that was considered a risk. Tenancy issues can also be a problem for people whose violent partners have caused damage to rental property or otherwise impacted their rental history as well. So if they've had to break a lease or had to move to escape violence. So those were the sort of issues that we were hearing about there. Which led us to recommend that discrimination on the basis of domestic or family violence should be unlawful, with a definition of that based on the current legislation as well for the meaning of domestic or family violence for some consistency there. The homelessness attribute as well. So we considered a variety of different potential attributes in this area, including accommodation status. But in terms of who the examples we were hearing about and who was in need of protection, we thought it was of most relevance that is people who are experiencing homelessness, who were experiencing discrimination that we thought should not be lawful. So, for example, we heard about people being discriminated against when they're looking for work or a rental property because they don't have a fixed address, or security of tenure, so including couch surfing or residing in a hostel or refuge. It might apply in education space. We also heard from youth advocates that some of their clients had been at risk of suspension or exclusion from school because their homelessness makes the uniform or homework requirements really difficult to comply with. It could include not receiving health services because there's no place to convalesce after receiving surgery, or perhaps just shopkeepers refusing service to a person who's sleeping rough. Yeah, so that's the just a brief overview of the additional attributes. Of course, it's the largest chapter in the reports. There's a lot more detail if you'd like to look up any of those and have a closer look. The final topic that I'll cover now is exceptions to discrimination. So an exception is where to discrimination is at the moment called an exemption. We think exception is probably better language and recommend that language instead. But it's where a respondent to discrimination can argue that it's not discrimination or shouldn't be unlawful because a relevant exception applies. So for example, there is an exception for workplace health and safety. There's an exception if a person wants to hire domestic services in their own home. So there's a range of exceptions in the Act, which we had a close look at. So we took a human rights-based approach to this, and we considered, well, what's the purpose of that exception there? How does it actually, what sort of discrimination is it permitting currently? What are other jurisdictions doing? Is that exception and like across the board and all state and territory and federal discrimination laws? We looked at whether there could be better harmony with federal laws. So if you've got a range of different exceptions between, say, the Sex Discrimination Act and Age Discrimination Act, and then the state laws, it can become very difficult for a duty holder to know what they can and can't do. We ultimately determined that some exceptions should remain in the Act, but examined those that should remain very closely to see if there should be any updates or changes to those. And we recommend changes and retaining but updating the following. So a non-profit exception, clubs, sport, religious bodies, superannuation and insurance, and prisoners as well. We do recommend removal of two exceptions, which are work with children and assisted reproductive technology. Without going into a lot of detail, these were very much out of date and stigmatising, and we thought very much need to go as a priority. So we won't have time to go through all the exceptions. Again, it's a detailed chapter of the report, but today we'll focus on the non-profit exclusion, which is most likely to be of relevance to you. Okay, so the current exclusion of non-profit suppliers of goods and services is broad. There's no other jurisdiction that we could find that has such a broad exclusion of non-profits. And it means that any association that's established for social, literary, cultural, political, sporting, athletic, recreational, community service, or other similar purposes that doesn't carry out its purposes for the purpose of making a profit, any association that meets that definition does not need to comply with the Act when they're providing goods and services. So that's meant there's been a range of cases about this, but it's even meant that the Wesley Hospital's not liable to its own patients because it doesn't carry out its purposes for the purpose of making a profit. So the test hasn't been about how much profit the organisation is making, it's just looking at the purposes that are set out in the Constitution. So as you can see, quite a broad exemption in its scope. We discussed this at the QCOS workshop last year, and we also did a poll, and just to remind people if they were there, 49% thought that the exclusion of non-profits should change, 11% thought that the status quo should remain, and 36% said that they thought it depended on the circumstances. So the issues that we heard about when we sought submissions on this is that we heard that this was actually creating social exclusion for some groups. So there may be people who are quite reliant on their local RSL, perhaps a person with a disability who can be lawfully excluded from attending that at the moment. This was limiting sort of access to justice under the law. And we also hearing that this was creating inconsistency with federal laws that covered the same conduct as well. So we heard one example where a person had made exactly the same complaint to the Queensland Human Rights Commission. It had, of course, not been able to proceed because of the non-profit exemption. made the same complaint then to the Australian Human Rights Commission 2 years later, and it was resolved with a good outcome. And the only difference was this exemption in Queensland. So there's sort of not a lot of logic in having different inconsistent exceptions between the state and federal laws. We, of course, thought it was important to recognise the work of nonprofits and the incredible work that is done, particularly in the community services area. But we also looked at the community reliance on nonprofits and looked at some research that QUT had done that indicated that, in fact, there is even more community reliance on nonprofits in Queensland than most other states as well, in terms of a range of services. And we finally determined we also considered that there needs to be a bit of balance here. So ensuring that small voluntary run bodies with few resources or facilities are not drawn unreasonably into disputes was another consideration. So we finally determined that excluding non-profit service providers from the Act was creating an unfair barrier to access in the Act. But we thought that there needed to be some balance. So, for example, small voluntary grassroots organisations that are, say, run from a person's home and have few or no resources, because there's also concerns around free association with others and the ability to worship or have cultural connections with others in the community as well. So in terms of what we recommended, balancing all of that, we recommend removing this existing exclusion for non-profits from the whole Act, but including a voluntary bodies exception to bring it into line with the Sex Discrimination Act and Age Discrimination Act. So discrimination is permitted where you're admitting persons as members of the body or providing benefits, facilities or services to members of the body. So in other words, you can have the choice to associate freely with others, but as long as it doesn't have a publicly discriminatory effect. So that means that, so a voluntary body would be those that are incorporated or unincorporated, the activities of which are not engaged for the purpose of making a profit. So just to give you a couple of examples. So a Catholic-run op shop selling goods to the public is liable for discrimination in terms of when they're providing those goods and services. But if a Catholic Bible study group was to meet, they would be able to lawfully exclude non-Catholics from that. So if a minority community organisation was holding an event just for community members to celebrate a significant cultural event, then they could lawfully exclude others from coming. But if the community organisation was running a market stall at a farmer's market to raise funds, they would be required not to discriminate when they're servicing the public. So that's one sec. So this would extend to probably a lot of the service providers of community and social sector services. So the others that it would actually draw into the Act that are not currently covered include like RSL clubs, surf lifesaving clubs. They, for example, could determine who's given a membership and obtain benefits as members. But if they had, say, a bar and pokies, then they're providing goods and services and they're therefore not exempt for those actions. Okay, so one of the questions on notice that we got was looking for information relating to what we might need to implement in policies and practices from the recommendation. So I thought I'd cover next, well, what's happening with this report, where are we at, and what do you need to do next to prepare? So the timeline really isn't clear. Our role as the Commission is now ceased in it. We do know that there is a government response which is being prepared by the Department of Justice and Attorney General, and we have heard that that will be released by the end of the year. And that's where the government will say which recommendations they will agree with or proceed with and which they will not. We're really hoping that it all will be implemented. But because of the broad and sweeping changes necessary, we've actually suggested that a whole new Act is drafted. So of course, that actually takes a lot of time to develop and draft legislation, and there's quite a lot already happening in terms of the Attorney General's portfolio at the moment. There will be a parliamentary committee process your organisation could be involved in order to provide your input once there is actually a bill in place. And I'm also sure that QCOS as a peak body would be involved in that time as well. So if the law passes, organisations would, of course, need to update any policies, procedures, And that could be in relation to new attributes, any exceptions that might apply. And then, of course, preparation for the positive duty. We would expect that there'd be a couple of years, maybe even 3 years, in order to do that work. And as I said, the Commission intends to put out a lot of general guidance for duty holders and then work towards more specific guidance for priority sectors as we go through in future. And then subject to our resourcing, we'd really want to prioritise engagement with duty holders, not just while the positive duty is coming in, but on an ongoing basis as well. So we did actually have a couple of questions on notice, and we've got quite a bit of time left, so we probably will have more time for questions after this as well. So the first, we actually were asked about how the review captured the voices and experiences of Indigenous LGBTIQ+ people. As I mentioned at the beginning, we consulted very widely, and we actually prioritised groups that experienced intersectional disadvantage because it is actually something we wanted to specifically cover, as we do in a chapter about discrimination and combined grounds. So we actually had a fireside chat with Two Spirits with a number of attendees, which was a really fantastic engagement. We also ran community surveys that were tailored to the community. So we co-designed a community survey with Queensland Council for LGBTI Health. And then there was just the general survey as well. And we did actually hear quite a lot from that cohort, which was great. The second question was, does the review have anything to do with ensuring culturally and linguistically diverse communities are provided with appropriately certified interpreters and not just with ad hoc bilinguals without training or qualifications? Now, I can say that this was definitely part of some of the discussions we had with organisations that support culturally and linguistically diverse people. But the reality is there was no need for reform. It's very clearly unlawful not to provide an interpreter. But unfortunately, we still continue to hear about problems in this area. So certainly people can already make complaints about this, and this is clearly covered by the law. But certainly there might be potential for this to be better addressed if there was a positive duty, as there could be more clear guidance for organisations about what they have to do to make sure that culturally and linguistically diverse communities are provided with equitable access to services. The third question we had on notice was about what's being done to prevent discrimination in inflated prices that females are required to pay for the same products as men. Now, that's not really a matter that came up during consultations, and probably isn't really a matter that's easily addressed through anti-discrimination legislation. I would suggest possibly something that the ACCC could investigate, but probably not very quite difficult to address apart from individually making a complaint against a service provider. So it would be a difficult one. And I do see that was the questions on notice. So I do see we've got Brendan with his hand up. So
yep, Brendan's got a question there, Heather. So fire away, Brendan.
Hello, it's Brendan Donaghy here. Can you hear me?
We can hear you.
Good, excellent. I guess I had two questions here. Number one was, has there been any raised concerns around organisations bringing in external law firms when complaints are not, or at the commission when you go for complaints? That would be my first question. So they don't keep it in-house, they bring in an external law firm straight away, which leads to complicated issues. That would be my first question. And my second question is, I'm fully supportive of the non-for-profit part of the Act being removed. And I guess what I would say here is I think it's very important around non-profits being aware of their requirements under providing accessible services, and around this especially leads to the education sector around non-for-profit organisations that are engaged by universities to provide services in the areas of being able to apply for university, not complying with accessibility requirements. And when they don't do this, it leads to forms of discrimination around people with disability not being able to get into tertiary education.
Okay, thanks so much, Brendan. So to address the first one, it sounds like you're concerned about law firms being engaged when it comes to the conciliation or the mediation processes that take place.
Correct, yes.
Yeah, and I was a conciliator for 7 years, and I know that it's really challenging to actually address some of the power imbalances that can arise during conciliation, particularly where there's an unrepresented complainant, and then you've got representation on the other side. And I certainly think that it's a very difficult thing, and should be addressed well through the process, where you know, measures should be taken to ensure that those power imbalances don't make that process unfair. I think creating more flexibility in the complaints process and not dealing with things as a cookie cutter would be one thing that we would want to improve on. That may address it to some extent. But I think the challenge is that if you were to start to say there should be no lawyers in the process, that could also really disadvantage complainants as well, because there are community legal services that will step in and represent complainants. So as challenging as it is to sometimes have lawyers in the process, that right to representation does need to be across complainants and respondents as well. And to say no to all could also be really difficult, or certainly make the access to justice even worse. So, but I definitely take your point, Brendan.
I guess the issue I would say to that is of recent times, it's been incredibly difficult for people with disability, in particular in the areas of discrimination, to get any representation at all, because they all say that they're at capacity, or they can't deal with it, or they don't think that we have a case. So the problem is more so we cannot get representation to represent us against these legal firms, and then they rock up with 4 or 5 lawyers who are directly fighting you. So I guess the problem that I see is not being able to get representation.
Certainly, and we have a whole chapter, which I haven't talked about today, about how the Act should be implemented. So we've said that there really needs to be much better resourcing for the Commission, so that we can actually address the current backlog that we've got in complaints, and also for law firms, so community legal services to be properly funded to provide that assistance as well. And I would say, Brendan, the sort of access issues that you're talking about here, if it's about disability access, the ability to make an organisational complaint might be another one that would possibly address this as well. Yeah,
that would be incredibly helpful, and I think would relieve the burden, I guess, of a lot of the individual people having to go through it. So yes, I definitely think that would certainly be a very helpful change.
And I guess on the second one, which is about accessibility of non-profit service providers that are working for universities, it's not necessarily something I think we heard about as a specific issue during the course of the review. But what I would say to that is that certainly if these laws are implemented, we see that the Commission would then have a dual role, not only dealing with complaints in a reactive way, but also starting to talk to organisations and individuals that are experiencing discrimination to sort of start to gather intelligence about what are the priority areas. And then the opportunity might be there to actually address those, proactively. So it's good to hear. Well, thank you for sharing the information about that.
I guess what I would say is it is quite difficult when organisations turn up and don't want to conciliate and just completely don't want to engage any further with you at all, even though you've gone to the effort of bringing key sector blindness organisations to the conciliation to actually explain the issue, and they've completely turned off, and they don't want to have any further correspondence, which was, I guess, a recent experience that I recently had to go through at the Commission with an unconciliated complaint of recent times.
Certainly, yeah. And I think, again, more guidance materials which are helping duty holders with what they can do to prevent discrimination is what I would say is potentially a better way for everyone's time to sort of deal with these issues, rather than individuals like this, making a complaint. So thanks for the questions.
I'll leave it
Brendan.
there. Thanks very much.
Thanks, Brendan, for your question. Heather, we've had a question come through on the chat. That was, just wanted to confirm what I think I understood from the presentation, is that understand that the recommendations that a complaint can be made regarding inattention to positive duty.
No, so there wouldn't be any sort of direct sort of right of an individual to make a complaint about positive duty. So that would probably just replicate what we already have in terms of a discrimination or sexual harassment complaint. So we haven't recommended that. We haven't completely worked out as a commission at this sort of early stage how we would start to identify the trends and issues that we want to prioritise and deal with. So rather than a person making a complaint, I think it would be more someone letting us know, or an organisation letting us know about an issue, and then we would decide if it's a strategic priority to actually address that. And it would probably be first going to that affected sector and saying what, here's working with them first to identify how the problem could be resolved, and sort of more in an informal way, firstly providing more guidance material, and then only in the most exceptional circumstances and quite serious issues would we then take sort of the more compliance type measures in relation to an issue.
Fabulous. Thank you for that, Heather. Did we have any other questions from our members' attendance? Anyone like to ask Heather while we have the opportunity here? And others come through on the chat. Caveat emptor, someone said, not every bilingual is an interpreter. Called members deserve language services only from NAATI certified interpreters.
Yes, all I can say is I agree. Certainly, and it's a shame that we keep hearing about it, which is, it's a very clear breach of the Anti-Discrimination Act. So certainly just again, I'm hoping it's something that potentially could be addressed better through a positive duty, because currently making complaints, it doesn't seem to be addressing the issue, which I'm hearing is still ongoing.
So we've got, I guess it's a extrapolation on the gender pricing inequities, but I feel like we did address that to some degree. So Jeanette's asked in a bit more detail around that. I'm happy to take that on notice and we can address that a little bit more. Did we have any more questions from anyone on the chat? While we've got Heather, it's a rare opportunity to ask directly of the Commission. And as Heather identified, it is important to remember that these are the recommendations from the Human Rights Commission. The government, the Attorney General, is still considering the recommendations. So it's a bit of a wait and see space as to what the direction forward from the government will be and the timelines from those. So it's likely we will have some legislative amendments. What those will be, though, will be a wait and see, and how long those will take to achieve. It doesn't look like anyone else has put their hands up. So I'm conscious that we're nearly at the end of our presentation, which we haven't gone over, which is a rare occurrence for human rights. And oh, Brendan, I can see your hand up. Did you have another question?
Sorry, I just remembered, it's Brendan Donoghue here. I just remembered within the time frame that you were saying to expand it to 2 years instead of 1 year, would that be COVID? Like if somebody had a complaint that was delayed due to COVID, would that still be a 2 year thing, even though that they had a delay within, or is that subject to without COVID sort of requirements being considered?
It wouldn't require any particular considerations. It would be that the Commission would then have a discretion to accept a complaint that is over 2 years within reason. so that if there were, exceptional circumstances that meant it needed to go more than 2 years, then of course we could consider that. But I'm hoping by the time that these laws pass that COVID would be a distant memory. That might be my me being a bit optimistic, Brendan, but yeah, it's it wouldn't be sort of the 2 years. It would just be the base. At the moment, it's 1 year. Exactly, it would become 2 years, and that's already what's happened under the Sex Discrimination Act for a number of attributes. So it's and it appears to be, it seems to be also happening to the federal laws generally as well. So to all attributes. So we'd just be going in the same direction.
In the same direction. Yeah. No worries. Thanks so much.
Heather, we've just got one final question, and it is, how do you find the implementation status of the Commissioner's recommendations?
I'm sorry, could you repeat that?
How do we find out about the implementation status of the Commissioner's recommendations, of the Human Rights Commission's recommendations?
Sort of keep up to date with it. Look, I guess we'll put out media as things go along, but the Department of Justice and Attorney General does take it from here, so they will probably also announce, I'm hoping in the next month or so, we're going to hear from the Attorney General about the recommendation. So that's all there is to look out for, I guess. Yeah.
And once a bill, so that as Heather identified, whenever they go to amend legislation, they have to put a bill before Parliament. So that will go before a parliamentary committee. So if you're a super keen Mad fan like I am, you can trawl through the parliamentary committee website and see what bills are coming up for review. I do that every Monday morning. It is super exciting, let me tell you, just to see what's out there and about in new law land. But if we don't have any more questions, I wanted to say a massive thank you to Heather for being here bright and early on a Monday morning to let us know about the report and the review. We look forward to seeing the outcomes of the recommendation and where the government takes the report. A special thank you to our audience for your participation. We do have a quick poll just before you go. This is from QCOS. It's popping up on your screen now to provide feedback about today's events, because this helps us to identify whether or not this webinar worked for you and to help us plan webinars in the future. So if you'd like to take a few seconds to contribute to the poll, we'd greatly appreciate it. If not, thank you so much, everyone, for your attendance today. We greatly appreciate it. As I said, we will send out a follow-up email with the presentation, the slides, and I'll also send a link to the full, what was it, a 400-page report, Heather? The link to on the Commission's website to the full report, Building Belonging, so that everyone can have access to that and read the full recommendations, as well as the vast amount of research that the Commission did and the engagement that they undertook as well. So I'm sure we will be in contact in future with our members when those recommendations come down and the next step in this process. Thanks everyone for your participation, and lovely to see you all.
Thanks so much, everyone.
Thanks, Heather.